question for Mike. Mike, can you see that question?
Yeah, the question about negotiating CBA with the firefighters and the average pay rates for the contracts that are being settled. The last numbers that I've seen, and that would have been last year, were slightly under 3%, so 2.5 to 3%. I don't know what that's going to look like at the end of this year. I am actually negotiating a number of contracts yet before the end of this year. And I've been talking to some of the union attorneys I'm negotiating contracts with. The tricky part is nobody knows exactly how much money they're going to have and of the money that they have between now and the end of the year and going forward, is it going to be tied to specific purposes, or is it going to be able to be used for wages and collective bargaining purposes? And there's no good answers to that right now. So when you go into negotiations, I think the first set of information requests you're going to get under PARA is going to be not only for the finances for the municipality going back for the last 3 years, which is pretty common, but also digging into what funds going forward are available through the federal government and whether that's something that can be available for collective bargaining purposes. I don't know exactly where this is going to go. So I think we're really looking at a variable here. My recommendation and the way I approach it is to err on the side of caution because a collective bargaining agreement is 3 years or whatever you reach on. If you don't know what the finances are going to look like going forward next year and the year after, don't commit to it, even if the funds are available right now. And you may get some pushback from the union saying we have all kinds of money right now. But in a CBA, you're going to have to look much further ahead than that and make sure you don't spend money that may not be available for those purposes. The mandatory vaccination question. Um, the question raises a number of points on mandatory COVID shots for uh, fire personnel and the rest of the employees. It seems like violation of personal rights, but it causes overtime and shift coverage concerns because of the quarantine. There's a number of issues that that question raises. The first, I think, is can employers have mandatory vaccination policies? And the answer is yes. The Equal Employment Opportunity Commission and a number of other agencies and experts have indicated that mandatory vaccination testing is not prohibited except in a couple of critical situations. One is if somebody has a medical condition that does not allow the vaccination, they must be considered for an accommodation for the requirement of vaccination. So it would be an ADA accommodation to find a solution other than the vaccination. You might also have situations where employees have religious objections to vaccinations, and that would come under Title VII, which also requires accommodation for religious objections. So you do have those two mandatory exceptions. But other than that, uh, vaccination policies that require that all employees be vaccinated would, for the most part, be enforceable. The question is, should they? Because there could be liability kicking in there on what a lot of employers are doing right now is they're taking a wait and see. The vaccinations, particularly with the J&J being paused because of the blood clots and whatnot, there's concerns that if you have a mandatory vaccination policy, somebody, because of that policy, gets the shot and then has an adverse reaction that causes serious illness or worse, could the employer be potentially liable for that? And I think that's an open issue that has a lot of employers taking a wait and see approach to that. With respect to the issue of quarantine, the CDC has changed a couple of their guidelines, and particularly with respect to vaccinations. Fully vaccinated people do not need to quarantine if they come into close contact, provided they're asymptomatic. So you do have that issue. There could be, and I don't know if this would fit in with fire, but this might be a situation where the policy could take into consideration where people are placed, or if they can work in person, and if they're fully vaccinated, that 14-day quarantine for when they come into close contact would not apply. The CDC also has special guidance for critical essential workers. And so for the essential workers that need to work, that are quarantining only because of close contact, the CDC does allow exceptions to that. So those might be a couple of ways to relieve some of the pressure on the overtime if the quarantine is solely because of close contact and not because of symptoms or a positive test. There's one, I think, real quick question. Are employees privy to other employees' wages? The simple answer is maybe. And the reason why I say that, as the employer, I would not provide anybody information on anybody else's wages. It's an employment matter, a personnel matter. As the employer, I would keep that confidential. But for union represented employees, the union certainly could get that information through a para request. And there's two statutes that would prohibit the employer from allowing employees to share that information. One, again, is para. The other is a Michigan statute that says employees have the right to share their wages and benefits with other employees. So even though the employer should not share that information, they cannot preclude employees from doing it on their own.
I do want to add something to that I think is important, because as Mike said, as the employer, you don't want to voluntarily give that information, but just as a piece of information, the Supreme Court's noted that public wages, even attaching the names to the wages, is subject to FOIA under the Michigan Freedom of Information Act. So your employees might be able to obtain that information that way.